Assalamu alaikum warahmatullahi wabarakatuh. Let me tell you about, in brief, about the Uniform Civil Code. As we all know, India is a secular democracy where the constitution guarantees the right to equality, freedom of religion, and cultural diversity. However, the personal laws based on religion continue to govern matters related to marriage, divorce, inheritance, adoption, among others. These laws differ for Hindus, Muslims, Christians, Parsis, and Jews. The UCC, or the Uniform Civil Code, commonly told in media as One Nation, One Law, proposes to replace these personal laws with a common set of laws applicable to all citizens irrespective of their religion, gender, or other identities. The UCC has been a contentious issue in Indian politics for a long time, and it is included as a directive principle of state policy in the Indian Constitution. Article 44, the Directive Principles of State Policy, Chapter 4 states, "The state shall endeavour to secure the citizens a uniform civil code throughout the territory of India." UCC mainly aims to replace the personal laws based on religion and community customs with a common set of laws governing marriage, divorce, inheritance, maintenance, etc. for all citizens irrespective of their religion. However, the implementation of Uniform Civil Code has been a matter of debate and controversy in India due to the diverse religious and cultural traditions of the country. UCC would ensure one law for the entire country which will apply to all religious and tribal communities in their personal matters such as property, marriage, inheritance, adoption. This means that the existing personal laws based on religion like Hindu Marriage Act 1955, Hindu Succession Act 1956 and Muslim Personal Law Application Act 1937 will technically be dissolved. Now let us try to understand what are fundamental rights. Fundamental rights are basic human rights enshrined in the Constitution of India, which are guaranteed to all citizens. These are applied without discrimination on the basis of race, religion, gender, etc. Significantly, fundamental rights are enforceable by courts subject to certain conditions. How many fundamental rights we have? You may want to know. 6 fundamental rights: right to equality, Article 14 to 18, right to freedom 19 to 22, right against exploitation 23 and 24, right to freedom of religion, Article 25 to 28. Every citizen can practice religion of his her choice. The Constitution guarantees equality of all religions before law and to secure to all its citizens liberty of belief, faith and worship. Article 25 to 28 provides religious freedom to all citizens and ensures a secular state in India. According to the Constitution, there is no official state religion. The state is required to treat all religions impartially and neutrally. And Article 25 guarantees all persons the freedom of conscience and the right to preach, practice, propagate any religion of their choice subject to public order, morality and health. Then the citizens also have cultural and educational rights. Article 29 to 30. Article 29 of the Constitution assures that the state shall not impose on minority community any culture, tehzeeb, other than its own. Further, citizens of India cannot be denied admission in state-aided or state-managed educational institutions on the basis of religion, caste, race, etc. Then there are articles like right to constitutional remedies, Article 32. Now coming to the DPSP, Directive Principles of State Policy. The Constitution lays down certain directive principles of state policy which, though not justiciable and are fundamental in the governance of the country, it is the duty of the state to apply these principles in making laws. These provisions of DPSP aim at ensuring socio-economic justice to the people and establishing India as a welfare state. DPSP are in the form of instructions, guidelines to the government at the center as well as the states. DPSP are ideals which are not legally enforceable by the courts for their violation. We need to understand these are principles. Though these principles are not justiciable, they are fundamental in the governance of the country. During the debates of the Constituent Assembly, the conflict over fundamental rights and uniform civil code was taken up seriously. Whether the UCC should be kept in the fundamental rights chapter has been settled by a vote. So we must understand, even when the Constitution was being written and framed, there was a discussion on this. So we can understand that during the debates of the Constituent Assembly, this matter was taken up seriously, and making uniform civil code for all the communities was not practical. So therefore Sardar Vallabhbhai Patel, who was leading the subcommittee on fundamental rights, said that the provision is out of the scope of the fundamental rights and kept it aside. There are other DSPS also, Directive Principles of State Policy, such as the states shall strive to minimize the inequalities in income and endeavor to eliminate economic inequalities as well as inequalities in status and opportunities, not only among individuals but also among group of people residing in different areas and engaging in different vocations as per Article 38(2). Then there is also another directive principle of state policy, where the state shall aim for securing right to an adequate means of livelihood for all citizens, both men and women, as well as equal pay for equal work for both men and women. So we are all aware that there is no equal pay for men and women even in the most modern companies, which are of software companies or in the agricultural labor. So these are the inequalities where it has been stated that the state shall provide, take measures to provide equalities. The state shall provide free legal aid to ensure that equal opportunities for securing justice is ensured to all and is not denied by reason of economic and other disabilities as per Article 39A. So these, the state shall endeavor to provide right to work, to education, to public assistance in cases of unemployment, old age, sickness, disablement within the limits of the economic capacity as per Article 41, as well as provide for just and humane conditions of work and maternity relief as per Article 42. Also, Article 47 directs the state to prohibit the consumption of intoxicating drinks and drugs which are injurious to health. Alcohol, however, is sold for consumption in most states of the country. Just taking the example of alcohol, when it is in the directive principles of state policy, that the state shall try to, it directs, Article 47 directs the state to prohibit the consumption of intoxicating drinks. The laws regarding alcohol is different in different states. So when they talk about one country, one code, even these laws are not uniform across India. Important to note that neither UCC is a fundamental right nor it holds any constitutional guarantee. Neither is it binding or mandatorily enforceable on government or the people. It is merely a goal, a guideline to which a nation should strive. Major opposition to the idea of UCC was the reason behind this Article 44 being placed as the directive principle of state policy, as unifying personal laws was very extremely difficult and impractical in a diverse and vast country like India. So as we are aware, India is a secular democracy where the constitution guarantees right to equality, freedom of religion and cultural diversities. UCC is unconstitutional. Why it's unconstitutional? It takes away the cultural and the religious rights of other minorities and tribals, which was promised to them by the founding fathers of the constitution, and it is a violation of the fundamental rights namely Article 25, 26 and 29. Also, UCC also fails to account for the intelligible differentia under Article 14. So, we also need to understand this, that India already has an optional civil code. As a citizen of the country, we have a freedom to follow religion or not follow religion. As a citizen of the country, we have the freedom either to get our marriages registered under the Muslim personal law if we are Muslim, or for those who do not want to follow religion, there is a Special Marriages Act 1954. This, read with similar acts such as the Indian Succession Act 1925, provides a good legal all matters of maintenance and succession for those who may wish to avoid religion-based laws. So now we need to understand, I hope all of you are very clear. Still, the students of law who would want to study and understand the arguments against the implementation of Uniform Civil Code, landmark judgment of S.R. Bommai versus the Union of India, the Honorable Supreme Court explained the concept of secularism as quote, the Constitution has chosen secularism as its vehicle to establish an egalitarian social order. Secularism is a part of the fundamental law and basic structure of the Indian political system, unquote. So, UCC is not non-feasible due to the diversity. India is a pluralistic society with diverse cultural practices, and uniform law of marriage, divorce and succession may not be feasible. It would be difficult to come up with a uniform set of laws for personal issues due to tremendous diverse culture in India. While the idea of UCC is a theory, in theory seems to be a great solution to cure all issues persisting in personal laws, practically in a country like India, it's not feasible. Not only do we have differences in law among religions, but within different sects and communities, tribes and regions. Goa is the only state in India presently with a uniform civil code which applies to all Goans irrespective of the religious and ethnic community. However, the same is not a complete uniform civil code. It has its flaws. It makes provisions on religious basis. For example, a Hindu man in that law can marry twice. Polygamy is allowed in certain conditions, such as when the wife fails to give a male child. Similarly, it also treats Catholic marriages with some preferences, and other marriages are not considered a religious ritual but only a contract. So basically, when we oppose the UCC, it is because of the infringement of personal laws. Many communities, particularly the minority communities and tribes, perceive UCC as a potential interference of the state in the personal matters and encroachment on the rights to religious freedom. They fear that a common code will neglect their traditions, set aside their views, and mandatorily impose rules of Hindu personal law on all citizens of the nation and violate their personal laws gravely, and would thus result in irreversible damage to the religion and the laws therein. So, this is where we stand, and most of the debates we need to go into the details, and whatever the media channels are feeding the youth in present day's time. Just a note from the Law Commission, 21st Law Commission, an 185-page report in 2018. They stated that UCC is neither necessary nor desirable at this stage, and the Law Commission recommended that discriminatory practices, prejudices, stereotypes within a particular religion and its personal laws should be studied and amended. So there is a strong debate that there is a need for gender justice and gender equality. So it is our duty to explain the Muslim personal law before the people and the rights of women in the personal law. At the same time, we have to explain how the laws are gender just and women benefit from these laws. So there is a huge responsibility on the intellectual Muslim class to explain and to come out and discuss with all the secular and even the liberal class and explain to them the Muslim personal laws are gender just, and this is where we need to work hard. I hope this talk has explained to the youth what is fundamental rights and what is UCC. Jazakallahu khair.